Hi, I'm Matt Drake of Drake QS Limited. This series of podcasts concerns do-it-yourself construction adjudication. In this series, you'll hear information from Peter Vinden, the Chief Executive of the Vinden Partnership, Paul Jensen, the Principal at Paul Jensen Associates, Michael Pye, the Principal at Pye Associates, Richard Barnes, Senior Consultant of the Vinden Partnership, Kenneth Salmon, Solicitor at Slater Healis, and James Driver, Partner of the construction team at Clark Wilmot, with questions posed by myself, Matt Drake. We hope you enjoy listening. So I'm joined today by Michael Pye of Pye Associates. This is another episode of Do-It-Yourself Construction Adjudication. Michael's been working in the construction industry for well over 35 years and has got a varied background and experience relating to dispute resolution. Michael, would you like to tell the listeners a bit about yourself, please?
Right, well, I started my career as an engineer, mainly working on construction sites, Taylor Woodrow up in the north of England, on what I call heavy building construction, which is reinforced concrete work, a lot of reinforced concrete work, a bit of motorway construction, and then I came through the ranks as a section engineer, site engineer, and then senior engineer. I ended up in Manchester in the early 70s after contracts involving, I know it sounds pretty awful, but sewage works are very interesting engineering-wise. And I completed a new sewage engineering works down in Swindon in Wiltshire. That was very interesting. Came up to Manchester and found myself on the annex to the Arndale Centre with a company called Poachins, and I was there promoted to senior engineer. Again, that was a very heavily reinforced concrete contract, and from there I went as a senior engineer on the new Manchester Metropolitan University on Oxford Road. I then went into the 70s. I then did a spell abroad for 3 years in South Africa, a place called Sasol, which was a huge development which relied on excavating coal, open cast coal, and converting it into petrol, and then a number of byproducts from that. And
that's it. That's quite an extensive. So just with the focus on engineering, did that cross over with any quantity surveying, or was it?
I did some quantity surveying, yes. But I had done all the prep work for quantity surveying. I think I went up to SMM7. That's been around a long time, hasn't it? But no, it was interesting reading drawings and so on, taking off the quantities and working up rates and so on. But I couldn't say that I did a lot of that. And as I say, when I was in South Africa, it was everybody wanted to be outside in Africa because the weather was so damn good.
Yeah.
That all you wanted to be was walking around in the brilliant sunshine, reading drawings and directing the works and so on. So that was terribly exciting. When I came back to the UK, I rejoined Poachin.
When was this, in the 90s?
No, we're in the 80s.
Okay.
And I rejoined Poachin, and they were grooming me for contracts directorship. I know that because they told me. And they thought the world of me, and I thought the world of them, I have to say. And they had some brilliant systems. The record systems that Poachins had, they had their own diaries in A3 format with several copies, and they had a system whereby the top copy went to the head office and the second copy down went to the architect and so on. But these are all basic things, basic skills, I think, that you learn only practically.
By doing them.
We also had standard day worksheets and allocation sheets and so on. Now, this might sound boring, but it's so very, very important. And even today, you get a lot of these disputes and so on. And the contractor who comes to you just hasn't kept his diaries, hasn't kept his allocation sheets and his records up to date. And I always have the view that, particularly with variations, you've just got to keep track of variations on a regular basis. And I used to insist on my engineers, for example, on the Manchester Polytech that I did, I had a team of 6 engineers. And the QS department, they had a team of 6 engineers. And I had a system whereby every single variation, it could be just a few bars of reinforcement, were required in addition to what was on the drawing. And at the end of the day, we used to write out, or get the engineer concerned in his section, to write out the variation. I used to look at it, and I used to hand it to the resident clerk of works. and give a copy to the QS.
Right, okay.
And they thought this was absolutely wonderful. The senior QS thought he was in heaven, because he was able to negotiate. Not only was he able to, undertake the process of the regular monthly valuations, but if he didn't want to process those in the interim valuations, he could leave them until he got to the final account stage, for example. And then he can use it as a bargaining chip. But he had it all there, you see. All the information was there, all cross-referenced.
I think, though,
with the drawings, with the revision of the dates, the reasons for the variation, it was all there. It was brilliant.
If somebody's producing that level of information and they understand the need and the benefits of producing that information, they'll produce it, won't they? Find that engineers or contracts managers, supervisors, if they don't necessarily understand what the end game is for records, they're not really focused on producing. They see it more as a chore.
Absolutely.
Whereas they might take some job satisfaction out of ordering materials and organising labour and making sure the plant's on site. They'll see records as a chore because they don't see, well, how's that getting the job done? And I think that's where that's where we have a bit of a downfall, or maybe why it's one of the common things of advice that consultants, lawyers, senior management in organisations tell the people who are working on site. It's all about records, and they keep telling them because it is all about records. When you come in to prove that your entitlement to more time or to a variation,
particularly if it's a disruption claim as well.
Yeah,
I don't think you stand much chance unless you've got very good records, allocation sheets and so on. And you have foremen on these large sites, and if they don't do the daily diaries and allocation sheets on a regular daily basis, if you ask one of these foremen, look, if he's missed a day or two, and then you say, well, look, where's the sheets, for Monday, for example? And it might be Wednesday.
Yeah.
And quite often they would struggle to remember what they've done.
Yeah.
And so it is in a legal system, isn't it? You get somebody in the witness box and so on. It's all very well when you refer back to conversations and so on. But, we're, as humans, we're all limited. We're all defective in as much as our memories are any good as really in the short term, aren't they? And what we've said and
it can be even
what we've done. So it becomes very unreliable evidence. Now, you contrast that now with clients who come to me now with their cases, either bringing them or defending them. And some of the records are just as bad as you ever imagined. I've yet just coming across good diaries, good record sheets, and so on and so forth. Even sometimes when you should have written a letter, maybe in terms of the contract, they should have put in the writing for an extension of time or whatever. And they may have missed the opportunity to do that as well. So the same mistakes are being made as were made a long, long time ago.
Well, this particular episode of the podcast is talking about conducting communications and conducting meetings, and just listening to what you were saying there, I think conduct at meetings, you can fast forward to the actual meeting, hypothetical one, and if it's coming down to a situation of he or she said this or that is or isn't correct, that can be overcome by keeping records. So you are avoiding a situation where the two sides have opposing views and are arguing across a table at a meeting, and that's obviously not good conduct. But you can overcome that by having good records. So what we've just been speaking about from a point of view of we don't keep them or why we should keep them, and I'm not suggesting that people would keep records in the anticipation of at some point in the future there being an adjudication and a meeting at the adjudication. You're going to rely on those records to prove your case. That's not what they think about. But what is good practice is to keep these records.
Absolutely. There was a recent case, actually, with an architect, recently being out in the last few weeks, the last fortnight. An architect called Dan Architecture, I think it was. And they lost a case that went before the courts. I can't remember too many details here, but the upshot was that the architect just didn't have any records. The judge was distinctly unimpressed and he lost the case. Yeah. So you've just got to be very, very careful. Yeah. Now, we're talking about preparation for do-it-yourself adjudication. So you've got to present your adjudication. We'll talk about the meeting first of all, and then we'll come back to the documents and so on. In adjudication, we have what you call meetings. Meetings are really for information gathering by the dispute resolver.
Yeah.
In arbitration, they're called
hearings.
Hearings, thank you. And in litigation, they're called trials. So in litigation, you have a judge and an arbitrator, you have an arbitrator and an arbitration, and in adjudication, you have a decision maker. And he awards a decision which is temporary unless it's overcome by agreement or by the process of either arbitration or litigation. So that's basically the process. So when you have a meeting, it's really for exchange of information for the benefit of the adjudicator.
Yeah.
It shouldn't be seen as an opportunity to put your case further or to argue with the other side. And the adjudicator will most likely not make a decision there and then on all the different heads of claim. A meeting may be useful, and usually is useful if you've got a final account arbitration and the parties can't agree, because usually it's quite complicated. And you have to go through a list of Scott schedule or something like that. And so it's quite often useful to demonstrate to the adjudicator with drawings, a set of drawings, and you can point to various things on the drawings regarding your claim, the rates of claim and how it's built up and so on and so forth. So that's good for meetings. Now, I now come to how you conduct yourself at meetings. And first of all, on the dress code side, usually you have an employer on one side, usually, and you have a contractor on the other side. So if you're representing the contractor wants to be reasonably well turned out, but you don't expect, for example, a concrete foreman to turn up in a suit. But he's just got to be comfortable, that's all, and tidy and comfortable. It might even be an open neck shirt. There's not a problem with that whatsoever. He's got to be fairly relaxed, of course, no swearing, which sometimes can be difficult because the parties can get a little bit overheated and so on. And usually at meetings, what I always insist on is an equal number of participants on both sides of the meeting. So if you're going to have a representative, you might have the representative on a long table. Usually I think the claimant would sit on the right-hand side. There's no written rule on this, and the defending party, we'll call it, on the left-hand side, and the adjudicator will be at the head of the table, and the person representative next to the adjudicator would be the representative. He would then have typically a quantity surveyor sitting next to him, and then anybody else who wishes to rely on or call, and maybe concrete foreman, should we say. And then there may be somebody, a senior representative of that company, a director, who is capable of making a settlement, agreeing a settlement. He would have that authority to agree a settlement. It's always useful if the two sides, if the adjudicator feels that there's a chance that the parties might like to settle, or if one of them asks whether they can adjourn the meeting to explore some ideas, then it's best to keep the iron hot. If the parties can go into a room and come to an agreement. So you need somebody of that authority. So that's the meeting.
Well, just before we move on. So if this meeting is taking place, and you've mentioned there about how the dress code of the individuals, that they should feel comfortable. You're not judging them effectively on whether they've got a shirt or tie on. It's the information that's going to be obtained from the adjudicator, which is important. But what are you hoping that you don't see? What conduct do you not want to see in this meeting from a behavioural point of view? Okay,
well, you don't want to see crosstalk. In other words, the person who's representing the party is the person who's should do the talking. So you don't want a free-for-all whereby, your QS next to you suddenly butts in and makes some sort of statement. You've got to appear slick and respectful of the adjudicator. You should always address the adjudicator. Any remarks you make to the other side should be made through him, but the one spokesperson is the correct way to have it.
Okay. And so would you think, obviously avoiding the crosstalk, and you certainly don't want to be seeing any kind of aggressive behaviour, finger pointing, shouting down of the other side.
Oh, absolutely.
It's allowing them, if somebody's speaking, then that person is allowed to speak and have the say. Do you set that out at the beginning? Is that how you...
Well, what I do, if for instance, I was the representative and I was asked a question on a QS item, and I feel at best that the QS on our side would be best answering that, then I'd say to the adjudicator, look, sir, can I just ask Mr. Jones here whether he can answer that question? He's our QS.
Okay.
And of course, you'll say yes to that, and that's the way to do it.
So you would invite the person
quite
to
often,
speak.
if it's complicated, if it's complicated or not, but particularly if it is complicated, I'd get the party that I'm representing to have a rehearsal a day or two before the meeting, and we'd get all the documents ready, all the files ready. We'd have more than one set of file. Of course, the adjudicator would have one complete set of we'll call it the file. It could be which could include the main bundle, which is the referral notice and the appendices to that, and any reply or response as well. They'd have all the copies of that. The other side would have identical documents, and our side would have identical documents. But I'd probably make a further set, at least one further set, for the QS or the contracts manager or whatever of our side, so that I keep one in front of me and they have one that they can share. And the documents would be set out such that they'd be very easily referenced. So in the main narrative of for example, the referral notice, in the narrative itself, which would be set out numbered paragraphs, one onwards, under select subheadings. And if you made a statement regarding, the works commenced on the 3rd of April, whatever, if you needed to evidence that, then page in the submissions, and that would be done slickly. So you'd make the statement in that particular paragraph, and then you say, see Appendix C, page 186, or whatever. So that the adjudicator, when he's reading the submissions, can read it with ease, and he's led directly to the evidence that you're relying on, the authority that you're relying on, even if you're citing case law. And he picks it up, so he doesn't have to go fishing in all the files to find out, what you've said is true. Okay, now if you're going to use, I'm going off piste here slightly, but if you're going to use case law, then what we normally do is we usually include the complete judgment of a particular case. This is the correct way of doing it. If you're citing a particular quotations, should we say, from a particular judgment, then that needs to be clearly highlighted in the case law, which the judgment which you've included in an appendix. And again, you just refer to that particular appendix, page so-and-so, and you go to that page and you'll see the words that you're referring to, your quotation, you'll just underline, or better still, just highlight with highlighter as well as underlining it. So he sees exactly where you're coming from and that. And you might cite from acceptable textbooks like Keating, and so on. And that's the same thing applies there. You can't beat judgments, of course. That's where we'll come from. But if it's that's the way to do it, so that the adjudicator, if you can imagine, if I refer to a male, I'm also referring to a female, of course. So that adjudicator might be sitting at his home, and he might have all the documents in front of him, a cup of cocoa in one hand. And it wants to be like reading a book. So, once upon a time there were two parties, this one and that one, and this one does so-and-so, and this other one is a contractor. And they had a contract, and blah, blah, and they fell out. And you want to take the adjudicator by the hand and show him the way home. I don't mean literally show him the way home. We want to show him the answer.
Yes. Putting a persuasive argument.
In a persuasive way, yeah. So you've got to invite the adjudicator, the decision maker, to find your view is the one to accept, and that's the whole idea of it. So,
well, just picking up there, because as the conversation has developed, we've gone from conduct at meetings into writing, and one of the things I thought we would just pick up on, whilst we still just bearing in mind, still thinking about meetings, is the importance of preparation for that meeting. And that preparation comes down to, as you were mentioning before, the adjudicator will have the bundle in front of them, the referral, the appendices, most likely the response and the appendices, and you're going to prepare a bundle for your side if you're a party rep, and possibly the other side will have their party rep will presented or prepared a bundle of information for them. But by being prepared, that can also assist with the conduct at the meetings, because people have the information in front of them there. It enables reference to points and facts to be made. And I kind of picked up on that as a possibility as we've gone through this conversation. So that's something I thought I wanted to recap on, just on that point there about how parties can, by being prepared, it can improve their conduct at the meeting. You've then taken the conversation forward and talked about documentation and how you're trying to put forward a persuasive argument to the adjudicator so that he or she can make an objective and informed decision based on your persuasive argument. In terms of conduct and in terms of content of submissions, can you draw on any instances whereby acting as an adjudicator, we were speaking before off mic, and you mentioned that you've presided over 40 adjudications. In any of those 40 adjudications, has there been any real derogatory content in written submissions which you thought, do you know what, that shouldn't be in there at all, that's not good conduct by the parties? Is this something that the listeners should avoid?
Yes, I think there is. There's two things I want to make there. 2 points is that witness statements, they can't be tested in an adjudication system realistically. But it does give the opportunity for the client, should we say, to vent off a bit of frustration. And I think that to a certain extent, they like to do that, some of them. And, it's sometimes best if in that situation, if they just write what they want. The important thing is that a witness statement is written by the particular witness in his own language, right or wrong, in his own style, his or her own style, very important, in his or her own languages and construction of sentences. And that gives weight to the witness statement. What you don't want to be doing is writing the witness statement for the witness and then just getting him to sign him or her to sign it. So you don't want to be doing that. I had a recent adjudication, a big one, and the winning party, in fact, they made submissions, and there were a lot of lever arch files on this, a lot of expert evidence as well. But the narrative that the referring party put forward was just so difficult to understand, and it just wasn't set out in a reader-friendly way. And it was very difficult, actually, to read where they were going, to understand it, and then to make the references that they subsequently made, to appendices and so on. Whereas the other side, and unfortunately they were the losing side, absolutely clear, and it does, I think, leave an impression very early on of, as you read through it, you start forming judgments, don't you? Little judgments in your head you make, and they can be conscious ones or subconscious ones, but you get a feel for it, because quite often, as an adjudicator, you never get to see the parties at all. And all you've got to work on, the two tools you've got, even as a party representative, you've got words, so you're a wordsmith, so you've got the power of words that you can use, and you've got documents, such as drawings or emails, letters, and so on, of course, all the contract documents. And they are the tools that you've got. And I just want to go back to a little bit of what I said before about persuading the decision maker that yours is the version to accept. And the words can be so powerful. So I'm now going to quote a little bit from Shakespeare. And Shakespeare, his mission was to woo his sweetheart. I think that's what his mission was. And so he used such simple words, such as when he was trying to woo his sweetheart, he said, her eyes, they shone so bright that even the birds would sing and think it not night. Now, there's no complicated words there at all. It's quite a short sentence. But the thing is, it's so sweet and simple and effective. And Shakespeare's mission was just to woo his sweetheart, like I said, and he did it in bucket loads. Another fellow that you might have come across, Churchill, we will fight on the beaches, in the hills and the valleys and so on. And at the time, it raised the morale of the nation, and it made the listener want to snatch his rifle and run onto the battlefield. We'll show them. And that was his mission, and he achieved it. So words can be very powerful indeed. And your mission is not to impress the decision maker that you're well educated, and even you may have got Latin O-level or whatever. So don't use complicated words. Don't use overlong sentences and so on. Sometimes the most effective sentence, I think, can be, I think somebody said that you have 3 words that could make a sentence. So And that's very effective. That could even be a paragraph. And how effective is that? That would really stand out.
Yeah.
So these are little tips which all help towards your submission. Latin, I use Latin a little bit, but I don't. It's only the well-read bits like inter alia. I find that quite useful to use, or things like that. So I wouldn't, burst out into song and dance on Latin, because keep it simple. Got to keep it simple, and remember that your mission is to persuade the decision maker that yours is the version to accept.
Okay.
And that you must always bear that in mind.
And that is, there's a conduct there in the style of writing, isn't it? And, you mentioned earlier, you're not there to convince the adjudicator how smart you are and that you've got a PhD or a master's degree. You're there to get the point across to prove the case. Now, that could be, I think I'm not sure whether it's a common phrase, but somebody, I'm sure, said to me, why use 20 words when 10 words will do? Get to the point, be succinct, make sure that what you're saying is logical, and you don't need to use, referring to your Shakespeare sentence a moment ago. Somebody reading that could know precisely what his intentions were, and he's not used any overcomplicated words. He's got straight to the point. And that's what I want. I think there's people who are considering starting an adjudication and representing themselves may fear. They fear the unknown, as we all do. But they might fear, well, what if I say the wrong thing, or what if I don't know how I should write this, or what style of writing I should do. But listening to what you're saying there is be persuasive, so that the adjudicator believes that your version of events is the correct version of events. Also, keep it simple, get to the point.
Polite. Be
polite, yeah. And then even if we go from documentation, we go to a meeting, for example, it's speak when you're spoken to, behave correctly. And last night I watched the last 16 of the Women's World Cup, England against Cameroon, and the English players behaved really well when the Cameroon players didn't like the decision that went against them, and they kind of had a bit of a demonstration on the pitch and they were causing a fuss, and the English players just walked away, kept themselves to themselves. And I thought that's a good example of how to behave. Good discipline, yeah. It's how to conduct yourself in a situation which is not normal. And, thinking to a meeting, if you've got two sides, opposite sides of the table, and one side is not behaving in the correct way.
They prepared themselves well. They were probably, look, if this happens, then we'll do this.
Yeah, and that's
discipline. That's good training.
And it's good conduct.
Good conduct. And that's really what you need to do if you're conducting your own adjudication. Yeah.
Well, okay. Well, I think we're coming towards the end of this podcast now, and I have asked a question of each interviewee. What piece of advice would you give to an individual, an organisation working in the construction industry? And that advice generally from a commercial perspective. What would you advise them to do which is going to, improve their situation on a day-to-day basis on a project?
Well, obviously records are right up there, aren't they, at the top? You've got to keep all your records, your diaries and so on. That's absolutely essential, isn't it? Is that what you meant?
I actually thought you may have said that when I was asking the question. But yeah, that's what I'm getting at. Because we have spoken earlier on about how parties don't keep records because the more, their intention is on getting the project done. But the importance of records are,
and the importance of drawings as well. Quite often on a large contract, you've got several hundred architect's drawings, several hundred engineering drawings, and you've got to be right on the ball with the drawings as well. You expect the contractor, to as he receives these drawings through an architect's issue, then you expect to have a date stamp.
Yeah,
well, that's absolutely quite simple, isn't it?
Yeah,
but you don't need a date stamp if you haven't got one. Write the date on it. Just got to say received 3rd of March, whatever. You circle it to something, and that's it. And then you get the old drawing, the one that's been superseded, and you just write on it SS.
I can remember.
And then put it in a filing cabinet, you see. And that's really good evidence that you come back to if you need to. But keep all your records right up to scratch, right up to date. And
that document control side of things is also important, which is a separate discussion altogether. But records, marked up drawings, photographs, emails, records of conversations that have taken place backed up in an email, all useful information. And I think we are kind of transitioning now away from not wanting to record something in writing because we don't want to upset somebody, to actually saying, well, do you know what, I'm just going to record it in writing because that's what
I've got a theory on that as well, and it's this. When you start out on a contract, you want to start out as you mean to go on, really. And at the very first variation you get, you might be getting along famously with the other side and the consultants and so on. The first variation you get, you write it out, you say confirm receipt of so-and-so and blah, blah. And they'll probably one or two of them probably take offence to that, actually. And they'll probably wonder what to do with it, And they'll put it in do they have in trays these days? I don't know whether they do, actually. But anyway, they'll put that there. And then they'd build up maybe 6 or 10 in a very short space of time of variations, and you've earmarked, detailed the drawing, the variation, and so on. But then, after that initial surge, if you would call it, it's generally accepted. It's not a problem anymore. Yeah. So right at the very first shovelful on site, and off you go. And then the QS, when he does his accounts and so on, he's got that to refer to. There's no dispute as to what the variation is, or there might be a dispute over who's responsible for it, but at least you've got it there in writing or what it was. And it makes the task so much easier, and it doesn't have to be necessarily complicated. And nobody minds that. And then at the end of the contract, you might be, several hundred of these, but that's a good contract. Yeah. If I was an architect or employee, I'd much rather have a contractor who told me where I stood right from day one, rather than a contractor who bottles it all up and then brings it as one big bang right at the end. So you don't want that. You want to know where you stand with all the variations and so on. The accounts can catch up with it, I suppose, but good record keeping is absolutely essential.
Fantastic. Well, thanks for your time. Really sure that the listeners will gain a lot from the information you've conveyed over the last 30 minutes or so. So thanks a lot, Michael.
Thank you very much.